This is Charles Goldstein, your advocate at work. Today I'm going to talk to you about the topic of discrimination. Unfortunately, there's always been a lot of discrimination in our culture. There always seems to be, and there likely always will be. But the best way we can deal with that in our society is to have remedies available at court so you can seek compensation if you're discriminated against at work. Now, there are many kinds of discrimination, but the focus in evaluating a case is whether the person being discriminated against is being mistreated or not favored or less favored than others because of their inherent characteristics of gender, religion, age, race, sexual preference, among many other types of discrimination. When proving a discrimination case to the court, it's critical that you have texts, emails, credible personal observations by you or others who have seen the discrimination take place. Without some kind of a proof, and it can even be your own testimony that's credible, you can prove discrimination, but hopefully in a context of having shown that this incident happened when you recorded it contemporaneously as to when it happened. Much more credible case for you to make in court. Now, what happens next in a discrimination case is that the employer will provide their reason for the unfavorable treatment, especially if it's a termination case. When the employer gives their reason, then the court looks to whether that reason is pretext. Pretext means that the employer is providing a reason for discrimination that doesn't make sense. The plaintiff pokes holes in it to show that it's not credible, makes no sense, or that it simply isn't the real reason the person was terminated, and it's actually discrimination. That's when you could well win the discrimination case. There are many statutes protecting you against discrimination, primarily the Minnesota Human Rights Act and Title VII under federal law. Now, there are many examples in which people have claimed discrimination over the years when the law wasn't ready for their claim. For example, claims under the Minnesota Human Rights Act for discrimination based on sexual preference. I wrote an article back in 1995 when the Minnesota Human Rights Act was amended to include sexual preference. Now, one of the first cases I learned about was a situation in which an organist from a church was terminated when the church found out that he was gay. He had a sexual preference for men. As soon as they found that out, he lost his job. That case made me angry. That person should never have had considered his sexuality in any terms with regard to employment. But playing the organ and losing your job because you happen to have a sexual preference for the same sex, it was absurd, and I got angry enough to write a very extensive article about this type of discrimination. So what kind of remedies are available when you have been discriminated against in employment? Well, there are many. Past income, present income, and future income. So past income arises when, by the time you get to trial, you've already lost some income because you were terminated. Ongoing income is all the income you're losing as time goes on when you're not being reemployed as the result of discrimination. And in some cases, even what are called punitive damages. That's a case in which there's been a reckless and willful indifference to the rights and safety of others by the employer, which certainly can be the case when you've been terminated based on a discriminatory motive. If you need representation in an employment case for discrimination, feel free to call me. I'm Charles Goldstein, your advocate at work, advocateatwork.com.